Hello and welcome. After a long time gap, I am making this video, and this video is on Reserve Bank of India Act. I hope it is to your liking and you find it informative. So let's start with the discussion on the various important sections, various important provisions of the Reserve Bank of India Act 1934. So let's start with the Reserve Bank of India Act 1934 as amended by the Finance Act 2022. So this Reserve Bank of India Act that is in front of you, it's a lengthy act. It comprises of 11 chapters, right? Beginning from chapter 1, that is preliminary, and it goes on to chapter number, what we say, chapter number 5, penalties. Now, I said that it contains 11 chapters. Why? Because if you see, there are amendments had been made in this act, and new chapters by the name of chapter 3E, 3F, 3D, 3C, and so on and so forth had been added later on, and that is why the total count of the number of chapters is 11. Apart from this, the act comprises of two schedules, that is the first schedule and the second schedule. At this point, I would like to inform you all that the the name of the scheduled commercial banks are mentioned under this schedule, that is the second schedule. Apart from this, the Act gives you the information regarding various amending acts, ordinances, regulations, and adaptation orders. And it is also a long list that has to be read along with the RBI Act because the provisions are, you can say, overlapping in nature in some way or the other. Then there is this list of abbreviations that are used at different locations, different places in the content of the act, in the text of the RBI Act. Uh, and this is the point from which we should be more concerned about, and that is the preamble. So Reserve Bank of India Act 1934, Act number 2 of 1934, and then there is a date 6th March 1934. Now, the preamble of the Act informs that this Act, that is the RBI Act, constitutes the Reserve Bank of India. And what is the purpose of the creation of the Reserve Bank of India? It is highlighted in the first paragraph, where it says that whereas it is expedient to constitute the Reserve Bank of India to regulate the issue of banknotes and keeping of reserves with a view to securing monetary stability in India and generally to operate the currency and credit system of the country to its advantage. So what is the primary purpose of Reserve Bank of India? Is to issue banknotes, the currency notes. Apart from this, there are certain other paragraphs, that is, and whereas it is essential to have a modern monetary policy framework, meaning thereby in the preamble itself of the RBI Act, it is mentioned that one of the tasks of RBI is to procure or to have a modern monetary policy framework. And whereas the primary objective of the monetary policy is to maintain price stability while keeping in mind the objectives of growth. And whereas the monetary policy framework in India shall be operated by the Reserve Bank of India. So from the preamble, we get the information that the RBI is tasked, is having the responsibility of the issuance of banknotes and to operate the currency and credit system of the country. Apart from that, to have a monetary policy framework and to maintain price stability while keeping in mind the objectives of growth. And finally, the monetary policy framework in India will be operated by the RBI. Now, if you see, there is this reference to this footnote, that is footnote number 3. So let's see what is this footnote. That paragraph 2 and 3 of the preamble substituted VDA Finance Act 2016, meaning thereby the original act, the original RBI Act, which came in 1934, was not having these points, these three points that are beginning with the word and. Now, these 3 points were not there. They were added later, and when they were added, it was added through the Finance Act of 2016 and with effect from 27/6/2016. And the Act itself provides that prior to the substitution, what was the content of the paragraph. So this is the situation with respect to the preamble and with respect to the functions that are to be performed by the RBI. Now let's begin with the chapter number 1, and that is preliminary. And the first section says about the short title, extent, and commencement. The important thing to note is that the act, that is the RBI Act, extends to whole of India. And the sections shall come into force. This section shall come into force. That is, section 1 shall come into force at once, and the remaining provisions of this act shall come into force on such date or dates as the central government may by notification in the Gazette of India appoint. Meaning thereby the government of India can have a single date for the operationalization or the commencement of the entire act, or it can choose different dates for the commencement and operationalization of the RBI Act, different provisions, different sections of the RBI Act. Moving further, let's see certain important definitions that will be appearing in the Act again and again. Uh, and these definitions have to be kept in mind while going through, while studying the different sections, and they are of pristine importance because the words that appear in the RBI Act, different terms that appear in the RBI Act, the meaning of those terms have to be construed accordingly as per the things that are mentioned in the definition itself. Now, what is the meaning of the term bank? The bank means Reserve Bank of India, constituted by this act. Likewise, what is meant by banknote? Banknote means a note issued by the bank, whether in physical or digital form under Section 22. Meaning thereby, while reading Section 22, while going through Section 22, wherever the word banknote comes into picture, it has to be construed, has to be understood accordingly. The central board of directors. Central board means the central board of directors of the bank. Consumer price index. The consumer price index, wherever it is mentioned in the act, has to be understood as the consumer price index combined. Mind you that the various organizations, various departments of the government come out with different consumer price index, like consumer price index for industrial worker, for agricultural laborers, and then there is consumer price index for rural areas, for urban areas. And when the rural and urban areas consumer price indexes are combined or are studied together, then that is referred to as consumer price index combined. So who publishes the consumer price index combined? It is published by the government of India from time to time. Moving further, uh, Deposit Insurance Corporation means the Deposit Insurance Corporation established under Section 3 of the Deposit Insurance Corporation Act 1961. Exim Bank means Export Import Bank of India. This is the another definition. Now, what is meant by foreign currency and foreign exchange? They would be having the same meaning as respectively assigned to them in the Foreign Exchange Regulation Act. Please understand this Foreign Exchange Regulation Act has now been replaced by Foreign Exchange Management Act. Industrial Finance Corporation, that organization which has been incorporated and established under the Industrial Finance Corporation Act 1948. Now this definition is important. Inflation, what is meant by inflation? Inflation क्या होता है? Inflation basically शुद्ध हिंदी में अगर हिंदी में बोला जाए तो इसको मतलब होता है मुद्रास्फीति. इन्फ्लेशन टेक्निकल सेंस में मतलब हुआ प्राइस राइज, जनरल प्राइस राइज. तो इन्फ्लेशन को यहाँ कैसे डिफाइन किया गया? हाउ इज इट इज डिफाइंड इन दिस एक्ट. इन्फ्लेशन मींस द ईयर वाइज चेंज इन द मंथली कंज्यूमर प्राइस इंडेक्स एक्सप्रेस्ड इन टर्म्स ऑफ परसेंटेज. Meaning thereby, year on year, what is the change in the consumer price index calculated monthly and expressed in percentage terms would be called as inflation. Next is inflation target. Inflation target means inflation targets that are determined in accordance with subsection 1 of section 45ZA. Every letter, every word is having its definite meaning. So please pay attention to these details. So inflation target means those targets regarding inflation which are determined, which are defined in accordance with subsection 1 of section 45ZA. Moving further. Monetary Policy Committee, another important, you can say, organization within the RBI. Now, Monetary Policy Committee, in short referred to as MPC, means the committee constituted under subsection 1 of section 45ZB. Just take a look that just prior to this, we have come across section 45ZA. This was related to inflation targeting. And then the very next section, that is section 45ZB, talks about Monetary Policy Committee. So it must be a common sense understanding that Monetary Policy Committee would be having one of the tasks, you can say, with respect to inflation targeting. But then when the this monetary policy committee will will come in the due course, we'll take a deeper look into it. In the meanwhile, let's move further. National Bank. National Bank, wherever it is mentioned in the RBI Act, National Bank means the NABARD, National Bank for Agriculture and Rural Development, which is established under Section 3 of the NABARD Act 1981. Then there is something called as National Housing Bank. National Housing Bank, which is established under Section 3 of the National Housing Bank Act 1987. Then there is something called as policy rates. In terms of monetary policy, whenever it is declared by the RBI, monetary policy in that particular document, policy rates are of extreme importance. And you must have heard of terms like repo rate, reverse repo rate, statutory liquidity ratio, cash reserve ratio, so on and so forth. Now, these all are what is called as policy rates, and where they are mentioned, which section provides them legality, it is section 17. So, policy rate means rate for repo transactions under subsection 12AB of section 17. So please take a note of it that policy rates, although defined, the term policy rate is defined under this section that we are going through, but the detailing about policy rates is provided under section 17, 17. Let's move further. Rupee coin, the 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 legal tender that we find in terms of coins that are part and parcel of the economic transactions that we encounter, that we go through every now and then. Now, it is defined as rupee coin means rupees which are legal tender in India under the provisions of the Coinage Act 2011, meaning thereby the coins that are issued, that are coins that are in circulation, they are also having some legal backing, they are also having some legality, and that legality is provided through the Coinage Act 2011. Let's move further. Scheduled banks. Scheduled bank means banks included in the second schedule. These scheduled banks are essentially the scheduled commercial banks that I have already talked about just a few minutes back. And then there is called a state bank. State bank means the State Bank of India, constituted under the State Bank of India Act 1955. There are the name of other organizations as well: State Finance, Financial Corporation, Unit Trust of India, Agricultural Operations, Cooperative Banks, so on and so forth. But the most important definitions I have just talked about them. Let's move to chapter 2, and that is with respect to the incorporation, capital, management, and business of the RBI. Now, it is section 3, which establishes and incorporates the Reserve Bank of India. An important section, therefore, that if a question is asked that under which section of the RBI Act Reserve Bank of India has been established, it would be section 3. So section 3 clause 1 says, section 3 subsection 1 says that a bank to be called Reserve Bank of India shall be constituted for the purposes of taking over the management of the currency from the central government and for carrying on the business of banking in accordance with the provisions of this act. Meaning thereby, prior to the creation of Reserve Bank of India, currency management would have been done by the central government, as it is mentioned in this portion of the subsection. So central government was doing the job of currency management previously, but once the bank, that is the Reserve Bank of India, was constituted, was established, the currency management function was taken over by the RBI under the provisions of Section 3, subsection 1. The bank shall be a body corporate. Let's move on to subsection 2. The bank shall be a body corporate by the name of Reserve Bank of India and having a perpetual succession and a common seal, and shall be said and shall by the said name sue and be sued. Meaning thereby the Reserve Bank of India would be having its own separate legal identity, and because of having its own separate legal identity, it can approach the court, meaning thereby it can sue somebody, it can take the course of recourse of the courts of law, and also some person can take RBI to the court of law for the settlement of disputes among them or between them. Now, what is the capital of the bank? Capital here means the amount of money with which the bank started its operation, you can say. The capital of the bank is 5 crore rupees. Coming on to the next section, that is section 6, that where would be the offices, branches, and the agencies of RBI, what would be their location, where will they be located. Now, the section says that the bank shall, as soon as may be, establish offices in Bombay, Calcutta, Delhi, and Madras, meaning there are about four locations which are mentioned by the name itself, and that too their old names, not the new names. Bombay, it was as of now it is called as Mumbai. Calcutta is called as Kolkata. Madras is called as Chennai. But the Act mentions the name of the respective cities by their old names: Bombay, Calcutta, Delhi, and Madras. Moving further, and may establish the bank, that is the RBI, may establish branches or agencies in any other place in India or with the previous sanction of the central government elsewhere. Meaning thereby, if new branches or new agency organizations have to be created, the RBI can do that on its own, or it can also, if it wants to open organizations somewhere else at other locations, then it has to take the prior sanction, prior permission of the central government. Now, section 7. Now, here is a note that I have made. Now, what would be the relevance of this? As you can see, this provision was used for the first time in the year 2018. But what is this? Now, subsection 1 of section 7 says that the central government from time to time gives such directions to the bank as it may, after consultation with the governor of the bank, consider necessary in the public interest. Although RBI is having its own separate legal existence, RBI is having its own functional autonomy to a large extent. But then again, the central government can give directions to the bank, and those directions would be pertaining to matters which are of utmost public interest. Now, the thing is, right from its inception, right from its birth, RBI has never received, you can say, directions from the central government under Section 7. In other words, that the central government has never given or never invoked Section 7 to give directions to the Reserve Bank of India. But this was broken. This trend was broken, you can say, in the year 2018, when for the first time the central government gave directions to the Reserve Bank of India with respect to the management of the various banking institutions, you can say. And there was, if you all recall, in 2018, when this news broke that central government has given directions to the RBI, it created big hue and cry in the economy, because this section had been invoked for the very first time. But then again, this all has happened, and the thing that you should remember is that this provision has been invoked for the first time in the year 2018, subsection 1, section 7. Moving on, the general superintendence and control. Who would be having general superintendence and control? General superintendence and direction of the affairs and business of the bank shall be entrusted to the central board of directors, meaning thereby the general operational control of the Reserve Bank of India would be in the hands of the central board of directors, which may exercise all powers and do all acts and things which may be exercised or done by the bank. So all that is necessary to ensure the smooth functioning of the RBI, so that RBI is able to manage all its responsibilities in an effective manner. All those decisions can be taken by the RBI, and essentially it would be the central board of directors who are interested with this responsibility in this regard. Moving on to subsection 3, the governor, and in his absence deputy governor nominated by him in this behalf, shall also have powers of general superintendence and directions of affairs and the business of the bank. Meaning thereby, central board of directors would be making the general regulations, and they would be implemented through the governor. But if the governor is temporarily unavailable, is absent in some way, or for some reason or the other, then the deputy governor, one deputy governor who is nominated by the governor to function or to implement those regulations on his behalf, would be doing the job of providing general superintendence and direction to the affairs of the bank. This is subsection 3. Uh, Moving on to section 8. Now, as we have seen that the general superintendence is in the hands of the the central board of directors, it is important that section 8 should inform that what would be the composition of the central board and what would be the terms and offices of its directors. Now, subsection 1 says that the central board shall consist of the following directors. Now, it is just like a any other corporate entity which would be having a board of directors. RBI is also having its own board of directors, which is referred to as the central board of directors. Now, central board comprises of the following directors, and the information is given in section 8. The directors would be a governor, at max 4 deputy governors, meaning there are a governor plus 4 deputy governors, which are appointed by the central government. 4 directors to be nominated by the central government, one for each of the local boards, and the local boards are constituted in section 9. So we'll be seeing it what is meant by local boards over here. But as of now, that apart from the governor and 4 deputy governors, there would be 4 directors which are nominated by the central government, and these 4 directors represent 4 local boards, 4 different local boards, and these local boards are constituted under section 9. Apart from this, 10 directors are nominated by the central government, and 2 government officials which are again to be nominated by the central government. So this is the composition of what is called a central board of directors. One governor, 4 deputy governor, meaning there were 5 in total over here. Then 4 directors representing the local boards, 5 plus 4 it is 9, and 10 directors to be nominated by the central government, it is 19, and 2 government officials to be nominated by the central government. By the two government officials that are nominated by the central government, the number comes out to be 21. So total number of members of the central board of directors is 21. Coming to subsection 2, the governor and deputy governor shall devote their whole time to the affairs of the bank and shall receive such salaries and allowances as may be determined by the central board with the approval of the central government. Nobody would be working for free, obviously. So the thing is that the salary structure and the allowance structure of the governor and the deputy governor is decided upon by the central board of directors, and it is to be approved by the central government. Uh, Now there is a proviso. The first proviso says, provided that the central board may permit the governor or deputy governor to undertake at the request of the central government or the state government such part-time honorary work, whether related to the purpose of this act or not, as is not likely to interfere with his duties as governor or a deputy governor, as the case may be. uh, the thing is that if the central government permits, then the governor or any deputy governor can take up part-time honorary work, meaning thereby no compensation would be provided for that part-time honorary work, which may be related to the provisions of this act, that is the RBI Act, or related to something else. But one thing has to be ensured, that the additional responsibilities taken upon by the governor or the deputy governor should not interfere with the primary responsibilities of the said functionaries, that is the governor or deputy governor. So this is the arrangement that has been provided. But then again, it has to be remembered that a request in this regard should come from the central government or the state government. The second proviso, moving further, the second proviso says that the central government may, in consultation with the bank, appoint a deputy governor as the chairman of the national bank. Now, what is this national bank? National bank is NABARD, as we have seen in the definition clauses. Section 2, if you recall, National Bank was National Bank for Agriculture and Rural Development. So, a deputy governor can be appointed as the chairman of the organization, that is the NABARD. And who would be making the appointment? It would be the central government. Uh, and the central government, before making the appointment of the said deputy governor as the chairman of NABARD, should do consultation with the RBI. Subsection 3 says that a deputy governor and a director nominated under clause D of subsection 1 may attend any meeting of the central bank and take part in its deliberation, but shall not be entitled to vote. Meaning thereby who would be having the voting rights and who would not be having voting rights, is provided. This information is provided in subsection 3. Now, what it says that a deputy governor and a director nominated under clause D. Now, what is clause D? Clause D is that two government officials which are nominated by the central government. So, two government officials which are nominated by the central government uh, uh, and the deputy governor, they are allowed to attend the meetings of the central board. They are allowed to discuss over the different points. They are allowed to deliberate on those points. But when it comes to voting, they would not be having the right to vote when the matter is put to vote. So this information becomes important, that although the central board of directors is a multi-member body, but the power structure, in the sense that who is having the power to vote and not having the power to vote, with respect to that, there are differences in that. Some of the members of the therefore the some of the members of the central board of directors are not having the power to vote, and this is uh, elaborated upon by subsection 3. Moving further, now this is this subsection 4, again an important subsection, that the governor and the deputy governor shall hold office for such term not exceeding 5 years as the central government may fix when appointing them, and shall be eligible for reappointment. A very common question, that what is the tenure of the governor and deputy governor. So it is not exceeding 5 years. The tenure should not exceed 5 years. But who would be ultimately fixing the thing? Who would be taking a call on that? Who would be taking a decision on that? It would be the central government. And at the same time, the 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 retiring governor or deputy governor is eligible for reappointment. The same person who has completed his or her tenure can be reappointed by the central government. With respect to the director, which is nominated under clause C. Now, what is this clause C related to? This is related to 10 directors to be nominated by the central government. If you look at the clause C over here, 10 directors to be nominated by the central government. So the information is regarding that only. Set 10 directors which are to be nominated by the central government. They shall be holding office for a period of 4 years and shall be eligible for reappointment. So governor and deputy governor, their maximum term can be 5 years. Their maximum tenure can be 5 years, and directors, 10 directors nominated by the central government, they would be holding office, to be more precise, for 4 years, and they would again be eligible for reappointment, provided that any director shall not be appointed for more than two terms, that is, for a maximum period of 8 years, either continuously or intermittently. Meaning thereby the directors, the 10 directors mentioned under clause C, they shall not be appointed for more than two terms, and at the same time, the maximum period of their appointment cannot be more than 8 years. Now, the 8 years can be calculated or counted continuously in succession or intermittently, in the sense that once appointed for a few years and then appointed, then again appointed after a gap of few years. That is the meaning of the term intermittently. Now, a director nominated under clause D. What is clause D? Those two government officials nominated by the central government. A director nominated under clause D shall hold office during the pleasure of the government. The pleasure principle applies with respect to those two government officials which are nominated by the central government to become the part and parcel of the central board of directors of the RBI. I'm sorry. Likewise, a retiring director shall be eligible for renomination. So this is the same facility that was extended to governor and deputy governor. The same thing is extended to a retiring director as well. Section 9, that is local boards. We have seen this reference to the term local boards previously. Now, local boards and their constitution and functions. Now, this is mentioned in section 9. Now, a local board shall consist for each of the four areas specified in the first schedule. Now, as I said earlier, that the RBI Act 1934 comprises of two schedules, first schedule and the second schedule. First schedule gives information of the different areas which are to be covered by the different local boards. Now, what are the different areas that are covered? It is provided, it is mentioned in this in this note that is attached, that is along with this file. The western areas, the entire country is divided into western area, eastern area, northern area, and southern area, and different states like states of Goa, Gujarat, Madhya Pradesh, Maharashtra, UT of Dadra, Nagar Haveli, and Daman and Diu. These states and these UTs comprise what is called as the western area. Eastern area shall consist of states of Arunachal Pradesh, Assam, Bihar, Manipur, Meghalaya, Mizoram, Nagaland, Orissa, Sikkim, Tripura, and West Bengal, and the Union territories of Andaman and Nicobar Islands. Likewise, the northern areas shall consist of J&K, Punjab, Haryana, Himachal Pradesh, Rajasthan, and Uttar Pradesh, and Union territories of Chandigarh and Delhi. Lastly, the southern areas shall consist of states of Andhra Pradesh, Karnataka, Tamil Nadu, Kerala, and the Union territories of Puducherry and Lakshadweep. Now, this entire segregation of different states and UTs into different areas has been detailed out in the first schedule of the RBI Act 1934. And for all these four different areas, local boards have to be created, and the composition of these local boards is detailed out in section 9. So let's see what is this. A local board shall be constituted for each of the four areas specified in the first schedule and shall consist of 5 members to be appointed by the central government. Now, how many members total in each board? 5 members to be appointed by the central government to represent, as far as possible, territorial and economic interests and interests of the cooperative and indigenous banks. So these local boards, each local board would be having 5 members. All the members would be appointed by the central government, and while making the appointment, the central government has to ensure that the territorial and economic interests and the interests of the cooperative banks and the indigenous banks have to be taken into account. The members of the local board shall elect from among themselves one person to be the chairman of the board, meaning thereby each board would be having a chairman as well. And who would be the chairman? This would be decided through election. And who would be taking part in the election? The members of the local board would be taking part in the election. Moving on to subsection 3, every member of the local board shall hold office for a term of 4 years and shall be eligible for reappointment, provided that any such director shall not be appointed for more than 2 terms, that is, for a maximum period of 8 years, either continuously or intermittently. The same logic that we have seen previously with respect to the central board of directors, the same logic applies here as well. A local board shall advise the central board on such matters as may be generally and specifically referred to it, and shall perform such duties as the central board may delegate to it. Now, what are the functions that have to be performed? First, advisory functions. Advisory functions with respect to those matters which are specifically allotted to them, and they would be performing such other duties and functions which the central board of directors delegate to these local boards. Coming on to section 10, disqualification of directors and the members of local boards. Now, first, with respect to this section, that is section 10, let's first see subsection 3. Now, subsection 3 says that nothing in clauses A, D, or clause E of subsection 1 shall apply to the governor or the deputy governor or the director nominated under clause D of subsection 1 of section 8, meaning thereby when it comes to the central board of directors, some exceptions have been given to them. As I've said in this note on the side, that the above mentioned conditions do not apply to the central board of directors of the RBI. So what are the disqualifications? Let's see them. No person may be a director or a member of a local board who is a salaried government official, meaning thereby a member of a local board or a director of a local board should not be a salaried government employee, should not be a government official who is receiving salaries. The concerned person should not be an insolvent, adjudged, adjudicated, or adjudged insolvent. Insolvent here means bankrupt. The concerned person should not be a lunatic or should not be of unsound mind. Apart from this, the concerned person should not be an officer or an employee of any bank. Apart from this, a director of a banking company within the meaning of clause C of section 5 of Banking Regulation Act, or of a cooperative bank, meaning thereby a director of a banking company which is defined uh, in the Banking Regulation Act 1949, or a director of a cooperative bank also is disqualified from becoming the member or a director of a local board. Apart from this, no two persons who are partners of the same mercantile firm, or are the directors of the same private company, or one of whom is the general agent of or holds a power of procuration from the other, or from a mercantile firm of which the other is a partner, may be directors or members of the same local board at the same time. Meaning there were two persons who are who are the partners of the same firm, or who are the directors of a private company, or one who is the principal and the other is the agent. If the two persons share a master agent or a principal agent relationship, also cannot be the members of the local board at the same time, meaning thereby both the persons, said persons, cannot be the members of the same local board at the same time. They can be the members of the local board at different points of time, that is allowed, but they should not be the members of the same local board at the same time when in their respective, you can say, respective organizations, which may be a firm, which may be a private company. They are the partners at the same time, and at the same as well as that they are the directors of a company. They can be the members of the local board at different point of times, that is allowed. But if they are at the directors or partners of a firm or a company respectively, uh, uh, with respect to their professional life at any given point of time, and are serving at the same time, they cannot consequently hold the membership of local boards at that point of time. So this subsection 2 creates an important disqualification. And as I said earlier, that subsection 3 deals with the exceptions that have been given to the members of the Central Board of Directors. Moving on to section 11, removal from and vacation of office. Now, the central government may remove from the office the governor or a deputy governor or any other director or any other member of the local board, meaning thereby the appointing authority, that is the central government, can remove the governor of the RBI, the deputy governor of the RBI, or any other director or any member of the local board. A director nominated under Clause B or Clause C of subsection 1 of Section 8 shall cease to hold office if, without leave from the central board, he absents himself from 3 consecutive meetings of the board convened under subsection 1 of Section 13. Now, what does this subsection say? If a meeting of the Central Board of Directors has been convened under Section 13 of the RBI Act, and the any of the directors which are those directors which are nominated under clause B or clause C of subsection 1 of section 8 are absent, and this absence has happened for 3 consecutive meetings that have been called under the terms of subsection 1 of section 13, then uh, uh, that particular director uh, can be removed from the membership, or as being the member of the central board of directors. Now, who will be about what which directors this subsection 2 is giving a reference? This is giving a reference to these 4 directors representing the 4 local boards and the 10 directors that have been nominated by the central government. If these 14 people, these 14 persons, they are consecutively absent for from 3 meetings of the central board, which is convened under section 13, then they can be removed. If they remain absent without taking the permission, without taking the leave from the central board. This is subsection 2. Then come to subsection 5. Now, subsection 5 says that the nomination as a director or as a member of a local board of any person who is a member of parliament or the legislature, meaning thereby can a member of parliament or a member of state legislative assembly or state legislative council, can that can such a person become the member of any local board. So the subsection says that the nomination as a director or member of a local board of any person who is a member of parliament or the legislature of any state shall be void unless within 2 months of the date of his nomination he ceases to be such member. Meaning thereby, if there is an MP or if there is an MLA or an MLC, and that individual has been nominated as a director or a member of a local board, then that concerned person has to either give up his seat in the legislature to become, you can say, a functional member or a functional director of the local board, and this has to happen within 2 months from the date of his uh, nomination in the local board. Moving further, if any director or a member, if any director or member of a local board is elected or nominated as a member of parliament or any such legislature, he shall cease to be a director or member of the local board as from the date of such election or nomination as the case may be. So now the thing is being talked about the other way around. Say, for example, if a member of a local board or a director of a local board becomes elected as a member of parliament or a state legislature, then from the date of that election or nomination, that concerned person will not remain, will cease to be the director or member of the local board. Meaning thereby you cannot function with two responsibilities. That is the basic idea. You cannot function and effectively by having two responsibilities. So either you remain the member or director of a local board, or you may remain the member of the concerned legislature, be it parliament or be it the state legislature. Going further, a director may resign from his office to the central government, and a member of a local board may resign his office to the central board. Director here means the director of the central board of directors can resign from his office by sending the resignation letter to the central government, and the member of a local board may resign his office, may send his resignation letter to the central board of directors, and on the acceptance of the resignation, the office shall become vacant. Meaning thereby the resignation letter has to be accepted as well. So if it is a member of a central board, the resignation letter has to be addressed to the central government. But if the concerned person is the member or director of a local board, then the letter has to be addressed to the central board. And once the letter of resignation has been accepted, the office will become vacant. Moving on to the next important article important section that has found its reference some time back as well, and that is section number 13, meeting of the central boards. Meeting of the central board shall be convened by the governor at least 6 times in each year and at least once in each quarter. Now, this is the statutory requirement with respect to the meetings of the central board of directors, that meeting of the central board shall be convened by the governor at least 6 times in each year. Every year, the meetings of the central board has to happen at least 6 times and at least once in each quarter. Subsection 2 says that any 4 directors may require the governor to convene a meeting of the central board at any time, and the governor shall forthwith convene a meeting accordingly. Meaning thereby the in the composition of the central board of directors, if any of the 4 directors of who are the members of the central board, they say that a meeting has to happen, should happen, then the governor should convene a meeting of the central board and this has to happen immediately. You can say the meeting has to happen immediately. If four directors are of the view that a meeting with respect to the discussion of a particular issue or anything of that nature has to happen, then the governor would be convening a meeting of the central board. Now, what is the requirement? How many directors are therefore required? It is, the number is four directors. So this is section 13. So as you must have seen that this RBI Act is a lengthy section. So in this session, I would be sticking myself till section 13 itself. For the next in the next session, I'll be taking up the some more of the important sections with respect to the RBI Act 1934. So till section 13, what all we have seen? We have seen the functional requirements, the functions that are to be performed by the RBI. We have seen the in certain basic definitions that one encounters while going through the RBI Act. Then we saw what is meant by central board, what is its composition. Then we saw what is meant by local boards, what is its composition, what is the area which is covered by the different local boards, and then we talked about the meetings of the central board. So I'll stop at this point of time. See you next time. Thank you.